On Tuesday, January 27, 2015, in the San Francisco Hall of Justice, with cameras rolling, Sergeant Brian Stansbury, an inspector for the San Francisco Police Department, arrested Deputy Public Defender Jami Tillotson for defending her client. Shouldn't he have to answer for that? Miss Tillotson's client was in court on a misdemeanor theft charge. When it was over, as he was leaving, Sergeant Stansbury saw and stopped him in the hallway to ask about an unrelated burglary. Someone told Miss Tillotson the police were talking to her client out in the hallway, so she went out to see what was going on. Sergeant Stansbury told her he wanted to ask her client some questions and take his picture about this other burglary. She advised her client he doesn't have to answer any questions or pose for pictures, and she refused the officer's request. Sergeant Stansbury responded by arresting her for resisting arrest and went ahead and took his pictures. There's a link to a video of the arrest in the description. San Francisco Public Defender Jeff Adachi is outraged, says Ms. Tillotson's client had a right to counsel, and how could they arrest his lawyer? But the San Francisco Police Department is standing by its man, saying Ms. Tillotson's client did not have a right to counsel because Sergeant Stansbury was asking about this other case, not the one he was in court for. That's sort of ridiculous. But you know what? It doesn't even matter, because whether or not he had the right to counsel, he had counsel. And Sergeant Stansbury arrested his counsel. After seeing that, do you think he thought he had a choice about whether or not to let them take his picture? But in fact, Ms. Tillotson's client was either under arrest, in which case he had a right to counsel, or had the right to walk away. If a police officer stops to talk to you, it's a consensual encounter, temporary detention, or arrest. Consensual encounter is no different than if I were to stop to talk to you. Legally, it means you're talking to the police because you want to. If you know what you're doing, you will ask the officer, "Am I free to leave?" If the officer says yes, then you leave. But you have to ask, because police officers do not have to tell you when you're free to leave. And if they don't have to tell you, why would they? The legal standard is whether a reasonable person would have felt free to leave. But what sucks in real life is the legal standard for reasonable person is often not reasonable. For instance, in a case called United States versus Drayton, 3 police officers got on a bus at a Greyhound pit stop. One of them stayed up front facing the passengers. The other 2 went to the back of the bus, making their way forward asking to pat people down for drugs. According to the court, 2 guys who were sitting on that bus with over a half kilo of cocaine duct taped to their boxer shorts consented to let police pat them down for drugs. Because, according to the court, a reasonable person would have known. You could have just said no to the police and gotten up off that bus. Right past the 3rd officer who, apparently, no reasonable person would believe was guarding the only exit. It's not always clear, so you have to ask, am I free to leave? If the officer says no, and if you know what you're doing, you will then ask the officer, am I under arrest? If the officer says no, you're not free to leave, but you're not under arrest, it's a temporary detention. If police have what's called reasonable suspicion to believe you're committing a crime, they can stop you to investigate, but only for as long as it takes to investigate. If you know what you're doing, you will then ask the officer, what is your reasonable suspicion? But if you can't remember that, then just ask why. And that's all they can ask you about, but not about some break-ins that happened last week. And they cannot move you. So if an officer asks, can you come with me, and you go, legally, you're going because you want to. Now, if the officer says, yes, you're under arrest, it's because the officer has probable cause to believe you committed a crime. At that point, if you know what you're doing, the only answer you will give to any question is, I invoke my 5th Amendment right to remain silent, and I would like to speak to a lawyer. Now, if you can't remember all that, you say, right to remain silent, lawyer. So when Police Inspector Stansbury saw and stopped Miss Tillotson's client in the courthouse hallway, it wasn't a detention because he was asking about some old burglary. So it was either a consensual encounter or arrest. The right to walk away or the right to counsel. Sergeant Stansbury arrested Miss Tillotson in front of her client for defending these rights. And so you tell me, shouldn't he have to answer for that? And there you have it, a little bit about the San Francisco Police Department arresting a deputy public defender in the San Francisco Hall of Justice. Thanks for watching, hope you learned something, and until next time, take it easy, everyone.